Good afternoon, ladies and gentlemen. Welcome to our Eating Disorder Hope webinar presentation featuring our special guest today, Elizabeth Green, Senior Associate at Cantor & Cantor. Today, Elizabeth will be presenting on how to write an appeal letter like an attorney, and we're so delighted to have her with us. Before we get started on our presentation, we just wanted to point out a couple things to you as our attendees. You will have the opportunity to submit text questions to Elizabeth by typing your questions into the questions pane of your control panel. You may send in your questions at any time during the presentation, and we will be collecting these and addressing them throughout the presentation. So feel free to submit questions at any time. And I would now like to introduce Elizabeth Green and turn this over to her for her presentation today. Welcome, Elizabeth.
Hi, thank you. Thank you, Crystal. Yes, I'm Elizabeth. I'm an attorney at Cantor & Cantor. We are a law firm in Southern California representing claimants to recover health benefits. And we represent families and patients themselves, and we work closely with treatment providers and clinicians on a lot of eating disorder cases. We handle appeals throughout the nation and litigation in California and several other states. We do specialize in mental illness and eating disorder claims, so this is right up our alley. And I geared this presentation to really all the families of patients or clinicians, whoever you are and whatever your relation is to the person who's needing the health care. I think you can benefit from this information. So it's meant to be practical and something that you can really use if you find that a health claim has been denied. So let's get started. And as Crystal said, if you have any questions, I'd love to take them as we're going along. It probably helps you along the way to get answers to your questions before we kind of move on to the next slide. So feel free to send them in, and I'll ask Crystal every now and then what she's got. So why we appeal? We ultimately appeal because we want to get the benefits paid, because there's been a denial and we think it was incorrect or wrong in some way, so we want to get the benefits paid. And we have other motives. We need to get treatment records considered because they probably weren't considered with the denial often. We want to fill the claim file with support for the patient's treatment. We want to exhaust the appeals. That means that we have done all of the appeals that are required under the policy before we file a lawsuit. And I have a little asterisk next to policy because I want to take just a detour and explain to you that there are policies and there are plans, and I do use them a bit interchangeably, but they're different. A policy is a document that ensures the benefits. So like you have an insurance policy for your car, you have an insurance for your health benefits. But not every health benefit is insured. Some large employers like IBM, Wells Fargo, I know I've litigated, they self-fund their plans. They don't have insurance for them. They self-fund them, and that means that they pay for those claims from their own assets or from a trust. And so there's a slight difference in a policy and a plan because plans, if they're self-funded, are not regulated by departments of insurance. But regardless, your takeaway here is that a policy or a plan is going to tell you what benefits are available and what you need to get those benefits. So you will hear this recurring theme that it's really important to know what benefits are available under your policy or your plan. So you have to have your policy or plan for that. And we appeal because we want to communicate. I really love this quote, the single biggest problem with communication is the illusion that it's taken place. And I think that I can speak for a lot of my clients and myself. I feel like this little girl in the picture who is yelling and trying to get my point across. My clients are trying to get their point across as to why treatment's necessary and benefits are required, and the insurance company is just not listening. So we want to make sure that we're communicating as clearly as we can. The insurance company, I want to make a point of saying that they don't have to say what they do what they say they're going to do unless it's in writing. They're really only obligated to follow their plan or the policy. So I can give examples. I'm sure you all have some examples of something the insurance companies told you over the phone but didn't follow through with. And one classic example might be that they're going to cover a benefit as in-network, but they actually don't. They cover it as out-of-network, something along those lines. So we want to make sure that everything's in writing so that it's clear. So Crystal, I want to just take a break here. Does anybody have any questions before I move on?
No questions yet.
Okay. All right.
Thanks.
We shall proceed. So the logistics, what we do to appeal, you can appeal in 3 ways. You can do an expedited appeal, which is often called an urgent appeal. You need to show that there's a medical need for the expedited basis. I've rarely seen where an eating disorder claim for residential or partial hospitalization didn't get approved an appeal on an urgent or expedited basis because of the need for that kind of treatment. And providers usually have these peer-to-peer calls through a telephone conversation with a doctor who works for the insurer or the claims administrator. You can do an appeal in writing, can send in a written appeal letter, and you can send in whatever you want in support of that appeal letter. Or you can just do a telephone call. It can be something as simple as just calling and saying, I got this denial and I'm appealing. That is not my recommendation, but in doubt, undoubtedly that's better than nothing, because you don't want to lose the chance to fight it later, and you will lose it if you miss your appeal deadline. So just make sure that you document a telephone call. Be really clear if that's the only way that you've communicated it. So our advice is the best way to appeal is to put it in writing. I find this is also pretty good therapy if you've had a particularly tough conversation with your insurance company or a good doc-to-doc that didn't go well. You want to put it in writing. Make sure that you confirm what happened from your end of the communication. So a written appeal is an investment in your claim. You want to do something today that your future self will thank you for, and that is doing a written appeal. This is why it's important. Whatever's in the claim file is what will be considered by the court later. If you lose your appeal, it happens, you want to make sure that you've filled the claim file with all the information that you have that supports the treatment. If it's not in the claim file, it won't be considered. Cases have been won or lost based on what was submitted with the appeal. So if you've got something, you've got to send it in. And if there wasn't a peer-to-peer by telephone, we do recommend at least you can fax treatment records in so they're in the claim file. You can follow up on an expedited appeal. It's okay. You can do it by phone, but you can also follow up in writing. So it's good to make a habit of that. Where to send the appeal? So talking about the logistics, you want to send it to the address is either in the denial letter or the explanation of benefits. You can send it to the address for appeals that's in your policy. Another tip, a reminder to get your policy, because it will help you know your coverage and know what you have to do for your appeal. I've seen this unfortunately quite a bit, that the policy has a different appeals approach or a different address than the denial letter for sending in an appeal. So sometimes I send it to 2 addresses. Overkill. It's great. The chances are it'll get to whoever it needs to get to. So use your best judgment on that. You want to send it certified mail. It's cheap and it works great. You probably won't have an email for whoever it is that you're sending it to. So sometimes that works, but you really want to get it in the mail because you then have some certified form of delivery. you need to mail it on time. So we are sticklers for calendaring these appeals. Generally, appeals for first level appeal, so you have a denial, if you're doing your first appeal, it's due 180 days from receipt of the denial. It's hard to know when somebody receives something. All we really have is a postmark, sometimes on the envelope. We have the date of the letter itself. So do yourself a favor and calendar it 180 days from the date on the letter, and that gives you a little cushion. And I didn't put this in the slide, but it's important to know that on a second level appeal, the time frame can be much shorter. It's often about 60 days. And this is important because if you have an expedited appeal that's done, you have a short time frame to do that second level appeal. And if someone is still in treatment, it may be that you're doing a second level appeal and the patient is still in treatment. So it gets a little tricky there, but it's going to help you just to know what your rights are, what your time frame is that you're dealing with. So make sure you know that either from looking at the denial letter or looking at your policy. Any questions at this point?
We do have an attendee wondering, is it safe to assume that I can appeal regardless of the reason for the denial?
You can always appeal regardless of the reason for the denial, but it's best to know what the denial reason is so that you know how to articulate your appeal. You can also appeal if they paid benefits, but they didn't pay them correctly. So that's something we often deal with too. If they paid at a rate that wasn't correct, or they mistook whether your deductible had been met, something like that, you can appeal that as well. So let's get to the heart of it. I'm sorry?
Oh, I just said thank you. That's it for now.
Okay, good. So what we're going to say, we're going to be organized. We're going to plan out what we're saying. We don't want to rant or ramble, as good as that might feel at the time. We need to date the letter. I've seen, unfortunately, a lot of letters that aren't dated, and it's kind of a guessing game as to when it was sent. What's helpful is also keeping a copy of the letter that you sent, not just the version that's on your desktop, but the letter that you actually sent with your signature, so that if you ever have to match it up later, you have the exact same letter that the insurance company has. And you want to say who you're addressing the letter to. Appeals department at the insurance company is going to be way better than to whom it may concern. This also goes for any letters that you get from letters of support. We'll talk about those later. It's good to put specifically who it's going to. And say who you are. Say what your relationship is to the patient, or if you're the patient, or if you're her clinician, and your contact information. And if you are a clinician, then put in what your qualifications are. How long have you been doing this? How long have you been treating this patient? Did you treat this patient previously? Maybe they came to you a year ago when you saw them, and now you're seeing them again, and things are much worse. So it's good to know who's sending it, and it gives it a lot of credibility. And then you also want to provide a brief biography of the patient. I give an example here. A patient is a 22-year-old young woman who suffered from anorexia for 5 years. She sought treatment at X facility due to uncontrolled escalating eating disorder behaviors in whatever that lower level of treatment was. So this gets to what some insurance companies, namely the Optum United Healthcare group, talk about as their why now factors. What is precipitated the treatment now? And sometimes it's something that just recently happened. It can be that there was just a rapid weight loss or weight gain or change in circumstance. It can be that this has been going on for a while and it is now gotten to the point where it really has to be addressed at a different level of care. It's whatever that is, it's nice to explain it briefly up front. It's good to talk about what other treatment that has been thought before this treatment issue, but I want to make sure everyone knows it's not required anymore. This requirement that used to be in policies and guidelines about failing first, we call it the fail first policy. The Affordable Care Act and the mental health parity laws do not allow that anymore. So you can't be required to try IOP, for example, before you go to partial, or you can't be required to do partial before you go to residential. And it makes sense when you consider physical illnesses, and when someone gets treatment for a physical illness, they don't necessarily have to try a lower level of care first. So just that side note, but it is nice to talk about what is precipitating the treatment at this point, because there's always something that's going on. And you want to summarize the prior letters, if there's a prior denial letter, and the documents. And you can quote directly from the denial letter. So the denial letter is really what you're going to tailor your appeal to. You're going to look at what is given in the denial letter, or it can be the explanation of benefits. It may not be a letter. An explanation of benefits can be a denial letter as well. So when you're looking at an explanation of benefits in EOB, you want to look for that little code next to the denial, and it's usually a footnote, and then look at what that reason is in that footnote. It's going to be really obscure. It's not going to be specific at all to the patient. It's just a generic code that they put in with a generic explanation. It could be something of no authorization, could be not medically necessary, but they're not going to give any explanation. But still, put it in, say, they said it wasn't medically necessary, and here's why they're wrong. So here's where you really get into it. You want to point out all the inconsistencies, all the things they've gone wrong, and you back it up by whatever you're providing with your appeal. So here's some common examples that we see. We see a lot of denials that are based on a patient's weight when a patient's in for an eating disorder claim. And sometimes the patient's bulimic, and weight isn't a criteria for a diagnosis of bulimia, isn't a criteria for admission. It's really a non-issue for a lot of bulimics. So that's a red herring right there. We see a lot of denials based on a patient eating 100% of their meals. And this is a real misnomer, because the 100% of the meals in supervised treatment, really whatever level of care they're at, outside of an outpatient, just, a therapy a couple times a week, if they're at IOP or PHP or RTC or higher level of care, they're getting group meals, they're getting supervision at their meals. And it's really important to know what kind of that supervision that entails. Often our clients had constant supervision at their meals to ensure that they ate close to 100%. They wouldn't have eaten that 100% if they hadn't had that supervision. And it can require redirecting during meals and snacks. I know that there's a lot of judges who, and claims people too, who really don't have any idea what this means. When we say constant supervision or redirecting, they don't know what a mealtime looks like in an eating disorder facility. They don't know what it looks like to have staff sitting next to patients who are having behaviors at the table, like cutting food into tiny pieces or hiding it or over-drinking, fluids, that kind of thing. And so I think it's important to point all that out, really explain it. Pretend like the person that you're writing this letter to doesn't know anything about eating disorders. Give them a little education. That's what we spend a lot of our time doing. And I know that some facilities have particular staff that sit with patients at mealtime and will take notes, and that's really their focal point. And if you can get notes from those staff members, that's great too, because you really want to get into the specifics here. So another example would be if the denial is based on the patient not binging or purging, engaging in those behaviors. it's really great to point out that the patient was being monitored after all meals and snacks to prevent such behaviors. And we have had some courts who it's like a light bulb goes off and they get it. And they're like, well, yeah, they weren't purging after meals because somebody's watching them the whole time. So that's not really enough to deny. And along those same lines, you want to be specific. Depressed is not specific, and anxious is not specific. You want to be specific as to what is going on with your patient. Crying, hiding under a blanket during group time, that's specific. This is an example from a case I was working on, but I'm sure a lot of people have their own examples of what this means. So we want to really get to the heart of it. We want to explain the facts that are supporting treatment, such as needing 24-hour supervision due to eating disorder behaviors at night. We see this a lot, that patients can be treated at home because they have someone, it's an adolescent particularly, they have family at home who can watch them at night, but it's not a family's job to ensure that their son or daughter is not getting up in the middle of the night and engaging in behaviors. So if that's the trigger time for some patients, then that needs to be explained. You want to be concise, focus on the facts, not opinions. Anorexia is the deadliest mental illness is a fact. That's a great fact to point out. You're the worst insurance company ever is just an opinion. Although it may be true for you, it's an opinion. So we want to keep it with the facts. The other thing that you'll come across are, of course, what the criteria are that the insurance company is using. And we always like to use the APA guidelines. They're online. They're easy to find. Put in APA guidelines for treatment of patients with eating disorders. And that's really what the only thing the medical community has, the treatment community has to go on for eating disorders. They're a bit dated now, and they're from 2006, although there was an update more recently, but they're a little outdated, and we do get that pushback sometimes with the APA guidelines. But I also think you can use the insurance company's criteria against them. You can show how the patient qualifies for that insurance company criteria too. Or explain how that criteria doesn't make any sense for this patient. It just doesn't apply. They might not buy that argument, but it's something to at least put in the record. You can build upon that later. But I always like to use the insurance company's criteria too. When they say you haven't met 1A and 4C and 3D, you can say, no, we have, and these are the ways that's been met. Any questions? Sorry, I'm talking a lot.
Elizabeth, we do have one question from our attendees wondering if it's necessary to also supply like hard evidence like therapy notes or weight logs from a treatment center and so forth.
Yes. Yes, and I'll get to that in the next, that was my next point. But yes, I think it's really important. This is just a letter, but the letter is going to be a summary of what you're giving. So we send in everything, the whole kitchen sink, honestly. We send in every treatment record we can get, along with a bill showing what was paid or what's owed. We send in links to different journal articles that support this kind of treatment. So yes, an emphatic yes to that answer, to that question.
Yeah, thank you.
And if you don't know what the criteria is that the insurance company is using, sometimes they talk about it in the denial letter, and sometimes they might reference it but not give you what it is. You can always ask for it from the insurance company. We actually have pulled out most of all the criteria that's used by all the top sort of major players in the insurance companies, from Aetna, Cigna, United Healthcare, Anthem, And if you want those, you can just email me, and I will be happy to give you links for those. It's really handy to have those all available online now. So you can get the criteria as well. You want to ask for the name of the medical reviewer who's looking at this. Under ERISA, which is the law that regulates employer-provided plans, you are entitled to know the identification of all medical professionals who review this appeal. And here's the full quote here with the site, so you can take that and put it in your appeal letter. And it doesn't matter whether they relied on that opinion or not. It's whoever they got advice from, who is a medical professional. It's helpful later because you will often find that they don't want to identify who the medical reviewer is. It's totally against ERISA, but it happens a lot. Or they use a medical reviewer who's not qualified. We've heard horror stories of the types of medical reviewers that are used. Usually they're psychiatrists. They're never somebody who's got any real experience with eating disorders. But sometimes they're not a psychiatrist. There's a medical director with Blue Shield in California who's an OBGYN. He signs a lot of letters. So it's good to know who is looking at your file. So here's what someone asked about what's enclosed. You want to say what you're enclosing with the letter. If you can list it all, that's great, but say what you're enclosing so that if the insurance company claims they didn't get it or it wasn't sent, you can say, no, they were sent. Here, remember I put it in my letter. And conclude with your specific request. You want them to overturn the denial and promptly pay for the treatment. So your enclosures that you referenced in the letter, these are your evidence. This is everything that's supporting what you said in your letter. You want letters from whoever you can get it from, who's going to support the patient's treatment. It can be from the treatment providers, can be support from family or friends, can be definitely, if nothing else, get your treatment records and send those in with the therapy notes. We find that often therapy notes, because there's some different HIPAA laws with therapy notes, sometimes they're not kept with the general treatment records at facilities, so you may have to ask for those separately, but make sure you get those. If there's any notes on the utilization review, this is a term that's used when the telephone calls occur between the provider and the insurance company. These notes should document those telephone calls that precipitated the denial and the appeals, and it's really helpful to have a provider who will keep notes of that conversation, because you'll find that those notes are going to reflect something different than what the insurance company notes say. And sometimes, if possible, if it's healthy enough for the patient, it's good to get a letter from the patient. I had a case recently with a patient who had a nice letter that it was short, it was one page that she did in treatment, talking about why it was really important that she continue on in that level of care. And it's really the only chance for the patient to get a chance to have their voice heard. It's the insurance company's voice, it's the treatment team's voice, but sometimes the patient isn't really heard at all. So it's nice for them to get to use their voice there. And then you want to mail it in. Focus on completion, not perfection. It's more important that it gets in, because that's the only letter that gets considered is the one that actually gets mailed to the insurance company. So you've mailed everything in, you're waiting, and your appeal is denied. And despite your best efforts, it's denied, and it happens, and it's frustrating, but you can move on. You can, there are steps that you can take, so don't lose hope. You can appeal again. If you appealed the first time, you can appeal a second time. Usually you can appeal a second time. But as I said before, you've got to be quick, because sometimes second level appeals can be due in as little as 60 days. So really keep track of that time frame. You could also request, this is for only insured plans, you can request an independent review from your state's Department of Insurance. This is similar to the appeal process, so it's really not going to be much different. All the steps that you took to do your appeal, you can do them again when you're submitting an independent review. You often have to fill out a form or some paperwork along with it. Shouldn't cost you anything or much. I think New Jersey costs about $50 or so. Sometimes they charge a little bit. The downside is that if the independent review comes down against you and upholds the denial, you usually can't litigate because courts are not going to overturn an IRO decision that came through Department of Insurance. And as I said, it's not available for self-funded plans. That's an option. Any questions?
We do have a question. At what point do you think it's necessary to get legal assistance in the appeal
Okay.
process?
So you can call an attorney. You can call our office if you choose anytime during the appeal process, just for quick questions. Am I on the right path? Is this what I should be doing? I think the answer to that, though, it varies from case to case. If you are doing all these things, I don't think that you necessarily have to call a lawyer, because I think that the setup should be, this process should be such that a layperson should be able to do an appeal. You shouldn't have to get an attorney to do an appeal. If you've done your first appeal and you've done all this and your claim got denied and you just don't know what you're supposed to do next, it might be good to call a lawyer then if you've done all the above. The question really comes when you get that denial of your appeal. What do you do next? And with that IRO decision, as I said, if you go to the IRO, it's really difficult to litigate afterwards. I can think of maybe one case where we've ever litigated after an IRO, and it's kind of a special circumstance. So we do have potential clients calling us who will ask about whether we would be willing to take their case or whether they should pursue the IRO. And sometimes we suggest they do the IRO because maybe their state is not one that we can litigate in, or the amount at issue is not something that we could handle. So I would definitely say if you're deciding on whether to do an IRO, it's probably a good time to call a lawyer, because that can change things a lot for you later. And I'll say too that we do work on a contingency basis, so we don't charge anything to look at files briefly, just to see what's going on and what stage it's at. We don't get paid for our clients who are retained. We don't get paid unless we're able to recover some benefits. So there isn't an hourly fee or anything like that that's involved. And we do a lot of pro bono work because it comes with the nature of these cases. But it is a lot that we require to be able to litigate. So you're seeing a good picture of everything that we like to see done before we can litigate a case. I think that, yes, okay, so that's getting into filing a lawsuit. You can file a lawsuit in federal court if you've exhausted your appeals and your benefits were provided through a non-governmental employer. We talked about ERISA in the beginning, and ERISA is when you get your benefits through an employer, and it has to be an employer that's not a governmental entity. It can be a private employer, but governmental is also thought of as not just your state, but it can be your county, it can be your school district, any city employer, that kind of thing. So there are actually a lot of governmental qualified employers that may not initially appear to be governmental. So that's just to say that generally you can go to federal court under ERISA if you've exhausted your appeals and you have that independent from the government employer, and what you can recover in federal court is your benefits that should have been paid under the terms of the plan and your attorney's fees and costs, and some nominal interest for not having that money for that period of time. If your benefits are through a governmental employer, or if you have your own policy that you bought on your own, depending on your state, you may be able to ask for punitive damages. So there's some extra damages you might be able to get because insurance bad faith laws that vary from state to state could come into play. So those are the different types of litigation that you'd be looking at if you end up going that route. That's it for me, but I'm happy to answer any questions or stay on if anybody has anything they want to go back to.
Thank you so much, Elizabeth. And yes, just to our attendees who are listening, feel free to submit any questions to the question panel of your control panel. And we do have a couple questions, if I can share or ask these of you, Elizabeth. One is asking, is it possible to continue with treatment even if the insurance coverage has been denied and then request that coverage back in the appeals, if that makes sense?
Yes. So a couple things happen. If you're in treatment, if someone's in treatment and insurance company initially pays, and then at some point the insurance company decides to deny further treatment, you really have two options, right? You can decide to stay in treatment and work a financial arrangement out with the provider, or you can decide to leave treatment. But you can continue in the treatment if there's a denial, and you can ask for all those days that you continue in treatment at that level of care. You can ask for those days to be paid. Essentially, you're going to be asking for all of your benefits for that treatment from the date of the denial through whatever your discharge is. This may be a little technical for some people, but if someone's in a certain level of care, we see this a lot with residential. If someone goes in at residential and the insurance company says after a period of time, okay, we're not going to cover residential anymore, but we'll cover PHP, then it's sometimes a choice of staying in residential and fighting for that benefit, or taking the PHP and, you know, downgrading the treatment, or taking the PHP and applying it to the residential stay, and the patient pays the difference. So all of that sometimes happens, but you can only appeal or recover benefits later in court for whatever treatment you stayed at. So if the insurance company says, no, we're not going to pay for this level of care anymore, we're going to pay for PHP, say, instead of residential, and you decide, okay, fine, then I'll go to residential. You can't, you really don't have any claim for that residential anymore because you didn't stay in. So if you want to, our advice is always follow whatever your treatment team's recommendation is. You know, they're the experts and they know you, and the insurance company doesn't. So the insurance company is going to do what they want to do, but it's not necessarily going to be in your best interest. So I know finances are always a concern when there's a denial, but our blanket advice is always follow whatever your treatment team recommends.
Great, thank you. A couple other questions. One of our attendees is wondering if Cantor and Cantor takes cases across the country, or is it just in California?
Yes, we do take cases across the country. We started doing these cases about, 10 years ago maybe, and have really been, in the last several years, we've increased the number of states that we litigate in. So appeals, it doesn't matter. We can do appeals wherever you are. It really doesn't matter where you are. You don't need an attorney to do an appeal. We do appeals. We do them for a slightly reduced rate of a percentage because there's less involved with them. So appeals doesn't matter where they are. The litigation that we have to file in court, we have many states that we litigate in with the use of our local counsel. So we have attorneys that we know from doing these ERISA cases in many states, and they serve as our local counsel. We come in and we're allowed to litigate there as long as we have local counsel. We are not licensed to practice law in other states, but we can do it as long as we have local counsel. So some of the states, just to give a range, we have cases in Washington and Texas and Illinois, in the Northeast, New York, Connecticut, Maine, Virginia, Florida, Georgia. I'm sure there's more. Utah. That's generally sort of, yeah, our range goes pretty far.
Thanks, Elizabeth. Kind of along those lines, or sorry, did you have more to add?
No.
Okay. We have someone else asking, if I'm seeking out legal help, what type of attorney should I be looking for?
You need an attorney who is going to work on healthcare cases, somebody who knows the field of ERISA. It's a little niche in the legal field to know these ERISA cases because it's a particular rules that apply. And to be honest, we're really the only law firm that does this, particularly for eating disorder cases that we know of. That we, as we said, we have local counsel who we work with, and sometimes we refer cases to them that we can't take for various reasons. But those attorneys do lots of other things as well. I can tell you 95% of my practice is eating disorder health claims. I have a few other health claims that aren't eating disorder. Maybe there's substance abuse or another mental health condition, or sometimes we get other health conditions for kinds of treatment that are denied for physical illnesses. But we really have worked hard to specialize in this area of the law because I think that it's really important to know a lot about the facts underlying your client's treatment. And a lot of people don't know much about eating disorder. So if whoever asked that question has a specific kind of geographical region that they're interested in, I'm happy to see if there's somebody that we know in that area, but I don't know of another firm that works specifically with eating disorder cases.
Thanks, Elizabeth. And another question is asking what success rate you've seen when seeking legal counsel for appeals.
That's a good question. And boy, it varies. Sometimes we send in really detailed, great appeal letters, and we get a denial. You know, we can send the best appeal letter in, and we get a denial, but we've set it up, and if we go litigate in court, maybe we have a great settlement in court, or we win at trial. And we've had a couple instances where we send in a quick appeal letter, and we get a quick approval. It's rare. Honestly, I don't think we've really found a pattern with the insurance companies, other than to say that generally insurance companies don't really know how to handle appeals. We get a lot of letters back denying appeals that don't make much sense. So I think that's due to the fact that they don't get a lot of appeals. They don't get a lot of comprehensive appeals, and they don't really know what to make of them. They're not really equipped to deal with mental health claims as they should be. I don't think that their staff generally knows enough to be able to assess these claims properly. So the answer is really it varies. I will tell you that for the appeals anyway. I will tell you that our success rate for litigation, it depends on the state in large part. The more conservative the judges that have been appointed, the less likely they're going to rule in favor of an eating disorder patient. It's just the way it goes, the rule of thumb, sort of. California is a great place to be because we do have a great Ninth Circuit that really takes their time to understand these cases. So we've done very well at the Ninth Circuit. And the district court judges, whoever tries the case, is it's just kind of a luck of the draw who you get. There are some states that are have become notoriously difficult to litigate in. I would say New Jersey tops that list. So sorry to anybody who is living in New Jersey, but move to New York for a while or something when you have your policy, because New Jersey is a tough one. Yeah.
Thank you, Elizabeth. And for some, we've gotten a couple questions from attendees who have like Medicaid. Is that something that you can work with to get appeals?
You know, we don't do Medicaid or Medicare appeals, but I met someone at the NEA conference last week who has had some success with a couple of those, and I could put whoever asked that question in touch with them. We don't. It's just a different area altogether in terms of what's required for those appeals. So no, we don't do Medicaid or Medicare.
Okay, thank you. And then this is the last question that we have. Just someone's wondering, what inspired you to specialize in this area of law? If you can answer that.
When did I decide to specialize in this area?
What inspired you to specialize in this area of law?
Mm-hmm. Oh, that's a good question. Well, I can tell you that I did not dream of doing this when I was in law school. This is kind of furthest from my mind. I actually was going into criminal law, but the LA County, we had a hiring freeze. So I started working at a plaintiff's firm doing insurance litigation and doing a lot of property cases. And out in California, we had the Northridge earthquake in '94, which resulted in a lot of insurance property claims. And I worked on those for several years. And then I came to Cantor & Cantor about 13 years ago and worked on another part of our practice, which is disability and life cases and long-term care cases. And I did fall in love with representing people who really had bad health problems, and I just felt it ups the ante when people are suffering with their health, and to have to go through trying to get disability benefits paid on top of it or long-term care. It became a great challenge that I enjoyed. And then we had a case several years ago with a patient who was at Kaiser and was trying to get residential treatment. And Kaiser doesn't have residential treatment. It was for eating disorder. And we didn't know anything about eating disorders, hadn't done any of these cases. And we lost and took it to the Ninth Circuit and won. And Lisa Cantor loves to tell this story because it's great, because when you argue to the Ninth Circuit, there's a panel of justices, and the first thing they asked was, how is she doing? And we think of that a lot because it reminds us that that's really who's part of our case here. It's a truly uphill battle to litigate these cases. The judges and the courts are not on our side the majority of the time. But the Ninth Circuit, like I said, the appeals court, they seem to be getting it. We're slowly making headway, and we're slowly making headway with counsel for insurance companies who call and I start using terms like PHP, and they say, what do you mean PHP? they don't know what kind of case they picked up either. And it has opened my eyes to what my patients or clients have been going through, and it's been a privilege to represent them. So I can't say that anything really inspired me to do this from a long time ago, other than I kind of came into it because the opportunity presented itself. But it's great, and I'll keep doing it as long as I can.
Thank you so much for sharing that, Elizabeth. And we just really appreciate the work that you're doing along with Cantor and Cantor in the eating disorder community. So thank you again for being with us today and for your time and sharing all this helpful information. We just really value your insight. So thank you so much.
Anytime. Thanks, guys. And feel free to email or call if you have specific questions.
Wonderful, thank you. And thank you again to everyone for attending our webinar today. If you have any other questions, like Elizabeth said, she has her contact information up. Otherwise, you can send us an email at info@eatingdisorderhope.com. Once you leave today's webinar, you will receive a survey on the presentation, and we would appreciate if you would complete that and provide your feedback. You will also receive a follow-up email within 24 to 48 hours with a link to view a recording of today's webinar. So on behalf of Eating Disorder Hope and our presenter, Elizabeth Green for Cantor and Cantor, thank you for joining us today and have a great day.
Thanks, Crystal. Thanks, guys. Bye.
Thanks, Elizabeth. Bye-bye.